You're with us today at the CCH CODIFI edition 2023, focusing on central bank digital currencies. And we have with us today Kleiner, who is a professor, a full tenured professor of law at the law faculty of Université Paris-Cité. And she lectures in private international law, international arbitration, international banking and financial law. Now, Professor Kleiner has also been invited to teach in so many universities abroad, including the University of Vienna in Austria, Kansai University and Doshisha University in Japan, the University in Buenos Aires in Argentina, the High School of Economics in Moscow, the Bucharest University in Romania, the University of Geneva in Switzerland, and she has spoken in various conferences held in France and abroad. Professor Kleiner's current research focuses on international commercial arbitration and international banking law, specifically on cryptocurrencies and central bank digital currencies. She has authored various articles in English, French, German, and Spanish, especially on international litigation, international banking law, and private international law. Now, she serves in many cases as an arbitrator and occasionally writes legal opinions in international litigations cases. Now, welcome and thank you so much for joining us, Professor Kleiner.
Thank you very much for the invitation, Geraldine.
Now, Professor, you've just contributed a wonderful and excellent paper, which is actually yet to be published. And so we'd like to discuss this. This is really real-time, fresh news really hot off the press, if you will. A wonderful article on the law applicable to central bank digital currencies, and that our audience will find in the book to be published this month, actually, edited by Professor Andrea Bonomi, Professor Matthias Lehmann, and Professor Shahiza Lalani. And that book is called Blockchain and Private International Law. Now, jumping right in, since we have Professor Kleiner with us now, in your paper, Professor, you have discussed distinctions between the uses of money as means of payment, as a means of storage, and as a unit of account, as well as the distinctions between the abstract and the concrete aspects of money. Now, Professor Kleiner, could you walk us through these different uses and why the different uses are significant in a legal context?
Well, thank you very much for having me and for this question. Actually, those questions I've been dealt with in my PhD, which I defended already 15 years ago in 2008. And I must say that from my perspective, I think that we need to distinguish between the three traditional functions that are distinguished in economy. So as you just say, the money as a means of payment, of storage, and unit of account. But I think that in the legal view, from the legal perspective, this function of storage of value is not so interesting from a legal point of view. So I really focused on the one side, money as a means of payment and money as a unit of account. So I think that what makes a money, this is the addition of both functions into just one thing. And so this is what I called in my PhD, but I was, of course, inspired by many other authors, among which another French author, Rémy Lipchabert, who wrote his PhD on the legal nature of money. And so this is what I distinguish the abstract aspect of money, which correspond to the function of evaluation, and the concrete aspect of money, which is the money that is moved, that is transferred, so money seen as a means of payment. And just if you allow me to go back a little bit in history, because I think that even if we are in the very modern times with the central bank digital currencies, this is very important to remember that in the Middle Ages, so this is very a long time ago, but in some countries, such as France, or what was France at that time, obligations were denominated in one monetary unit, which were the pounds or the livres. But then the payment was enforced in what would be called the real money, so in gold, in louis d'or, or in the écu. So there was a distinction that was really visible by all the people. But now this distinction between the unitary monetary unit and with what we do pay this is invisible, this division, because we use the same name, the dollar, the euro, whatsoever. This is always the same name, but still, there is still a dual function, and so a dual legal nature, if we could say. And this is very important from a private international perspective, as it can entail the application of different laws.
Thank you so much. That is actually a very good historical context, at least. I mean, we were very used to having pounds of gold in hand, and that has changed, but the concept has not actually changed, even though now in real life we're not carrying gold around anymore. But I think you touched on a particularly important point, because crucially it's the different governing law which applies to different aspects of money. And I'm wondering, could you please elaborate on this? So, for example, the lex monétaire, the lex causé, and additional applicable laws that may come into play with CBDCs, for example.
Yes, I think that this distinction that may seem a little bit abstract when we speak about something that is very concrete, which is money, but still is important to understand the different laws, and I'm using, of course, the plural, that might be applicable to money. So what is called lex monétaire, this is a concept that I think this is a principle of international law that exists, that has been recognized by the Permanent Court of International Justice. And lex monétaire is the law by the issuing state, and this is the law that applies to the abstract aspect of money, in my conception. But when it comes to the concrete aspect of money, I think that then different laws come into play. First, there is possibly the lex causé, so which I mentioned in this article that you so kindly refer to. So this is the law of the underlying obligation that justifies a payment, but how the payment will be made, I mean, through which instrument this payment will be made, has entails the application of a different law. So if the payment is made through cash, just I owe you 100 euros, so I give you a bill of 100 euros, then I think that the law here that are at place, this is the law of the issuing authority. So in our case, in the case of euro, of course, the law of the European Union. But if I have to pay you through a transfer, so using my banking account and your banking account, then of course we have most of the time two intermediaries. And so that means that the law of this intermediary might be applicable. The law that applies to the bank might apply. And then we should also take into account, we really love Latin expression in private international law. So this is what is called the lex loci solutionis, or the law of the place of the payment, which a state apparently can also rule what is permitted and what is prohibited within its territory in terms of payment. And so that is also a law, a legal order that should be checked in the payment, monetary payment. And when it comes to CBDC, there we can think also of the application on the law applicable on data protections, because of course many datas are going through the process of payment, and some protection is needed. But then the question comes, which the protection of which law, of which legal order should apply in those payments?
Thank you very much. I think, already in various discussions that we've heard today and during this colloquium, and of course you explore in much greater detail in your work as well, the use of CBDCs for cross-border or international payments has been highlighted as requiring distinct legal frameworks, in addition, of course, to the technical approaches. Could you walk us through perhaps what transformation, if any, do you anticipate is necessary for national and global legal frameworks? And how would these changes account for the cross-border use and circulation of CBDCs?
If a state decides to issue a CBDC, or sometimes some states together, this is the case for the $100, for instance, they will need to adapt their legislation, I mean, the law of money and the law of payment, probably they will need some adaptation. But then you asked me the question about the necessary change maybe on a global scale. And here I think that this is more tricky, because this is also the paradox, I mean, of all these new theme of the issuance of CBDCs, where even if the technology would entail the states to decide on a common ground, I mean, to issue maybe an international currency, I mean, that would be possible with the technology. But everyone is just deciding to issue its own CBDC. So with some exception that we know already, or some projects that are right now. But there is not this common will, I didn't see it, to enact a monetary unit that could be of an international use, and maybe also that could be used for international payment. So that means that on a global scale, as long as we do not have just one common monetary unit, I don't see just, I mean, one global, some rules that would apply to just one CBDC, or that could be applicable to the variety of CBDCs that will be issued by each state. So I don't think that there's a one-fits-all provision, you know, on the global state, but that we will still need, private international law rules in order to coordinate all the national legislations where the state will decide to issue CBDCs.
Thank you very much. I think you're right, spot on when you're talking about the non-unification, let's say, one global currency that won't need the sort of aspects. And thank you for walking us through as well the private international law considerations in ensuring the interoperability, the cross-border use and circulation of CBDCs. But in your last intervention, you mentioned this difference of, say, this idea of issuing of the CBDC. And could you talk about the difference between the law of the issuing authority and perhaps the law of the issuing country, and the implications that this might have on the lex monetaire?
Yes, here I must warn that probably I was influenced by my personal being a European and living in the Eurozone. Because we are living something that doesn't exist anywhere else in the world, to have this common currency, not among the 27, but now 20 member states. And so that gives the European Central Bank a specific power, because this is not the law of just one state, but this is the law of one system, the European Central Bank, and all the national central bank that belong to the European system of the central bank. So I think when I'm distinguishing between the law of the issuing authority and the law of the issuing state, this is when there is this discrepancy between not one currency for one state, but one currency for many states. But also, let me, if I have some time to elaborate on this, that when this distinction also is based on the principle of independence that is prevailing now in monetary law, or I could say in central banking law, because now this is this new branch that exists, central banking law. And even some authors think that the independence of central banks is a principle of international law, because this is so rooted and so important for the preservation of the economy, etc. So given the fact that central banks are probably the most independent authority, well, put in place by the state, but in the meantime, very separate from the state, according to many laws, and this is the case in the European Union, that makes this institution, the central banks, also maybe as having the same position as a legislator for all those issues. So maybe this is also what influenced me to make this this distinction.
No, thank you. That's actually a very fine but crucial distinction, I think. But if I may, I want to go back to this matter of interoperability, so the convertibility. As you said, you are present in the Eurozone, and that's quite a particular, let's say, framework that does not exist throughout the world. Could you perhaps walk us through what particular legal challenges arise in the use of CBDCs, in particular when you consider interoperability and the convertibility of different CBDCs, and the determination in this case of the validity of payment, which you, I think, have written on several times before, also in this chapter that we referred to as actually a key issue. So in that case, what would the specific applicable law be? Why is it important to consider the validity of payment? So we've had experts talk about the need for interoperability from technical perspectives, from legal perspectives. Perhaps if you could just talk us through that and tell us in the sense of payment systems, so cross-border payment systems and the validity of that, what kind of considerations would arise?
Yes, interoperability, this is really a key issue when it comes to the issuance of CBDCs, because in my understanding, the emission and then circulation of CBDCs will be made through different routes than how today private money, commercial money that consists of deposits on a banking account is circulating. So I like to compare the payment systems with roads or highway. A payment system is a network of highways, or we could also use railroads, for the train. And so each country, we could say, has its own locomotive, its own measures to construe the railway. But for cross-border payments to be able to be possible, you need that the locomotives be able to run or to be conducted on all the other railways. So you need to find some coordination on what is the width of the railroad, etc. So I think that for CBDC, this is interoperability. This is a term that I cannot say in English. I'm sorry. Is very crucial, because imagine I have some, let's say, digital euros, and I would like to pay a creditor in the United States. Am I allowed to do it with digital euros? Well, that's the first question. Is my creditor allowed to receive digital euros? This is another question. And so this is the same issue, but asked differently. And so possibly there are two different laws, for instance, here that would be applicable, okay? EU law and the law of the United States. So of course, we need just to have one law applicable for the validity of this payment. And so all the talk that you will have at the Hague conference is to discuss, well, what is the most relevant in order to make this payment valid, because at the end, of course, the validity of the payment is what is sought, so that the debtor can be freed from its obligation. And so these answers are made through the techniques, of course, through the technologies, because now, since this is all electronic, then some system can prohibit, I suppose, the payment when the receiver of this payment is located in certain area. But then, of course, this kind of technology must be transposed into law and to, well, decide which law should prevail. So I don't have really one answer, but I have a view on what are the problematics.
Thank you for that. And also thank you for that very evocative analogy with railroads, which I particularly like, because, of course, one of the ideas of having digital currencies and so is to democratize access to finance and to capital, especially across borders. Now, when we're talking about that, it's really a consumer to consumer type consideration. And I think this kind of also leads to one of the items that you've identified as well as something being most prone to a conflict of laws analysis, and that's retail cross-border use of CBDCs. And you've identified that specifically that the retail cross-border use of CBDCs would be the implementation most likely prone, I think you've written, to a conflicts of laws analysis. Now, could you explain to us why you think this is the case? And in your opinion, what could a conflicts rule look like? So, and how it would respect the principle of technology neutrality in light of so many different possible implementations of CBDCs?
Well, I can answer to the first one. The second, I'm not sure. For the first one, yes, I focused on the retail payment and cross-border retail cross-border use of CBDCs because I think that the other kinds of payment, which are massive payment or gross payment, concern more in the interbank payment system. And many authors think that when it comes to the interbanking relationship, CBDCs in a way already exist because they have already their roots for the netting system. So between the, I was not interested in analyzing the conflict of laws that could occur between banking in the relationship just between banks. And I think that where conflict of laws issues will arise is when a non-bank party will use a CBDC for its payments and paying another creditor that is not a financial institution or a bank. So this is why I think the focus of the conflict of law rules should be on the retail payment system. And what could conflict of rules could look like? That's really for the expert to decide. But my feeling and my thought is that the lex monetae, which we just started the discussion by mentioning the lex monetae, is an old concept, and in the traditional view, so applies only to this abstract aspect of money. But I think with the evolution and with the fact that many states will issue probably CBDCs, we will see a growing role for the lex monetae. So if I take the example again, and I'm sorry for that, I don't want to be too Eurocentrist, the example of the digital euro, the law of the EU will be, of course, more and more important as the lex monetae, as the law of the European Union, which has decided, which will probably decide to issue the digital euro. So that means that the material scope of the lex monetae will grow with the emergence of those CBDCs.
Thank you. That was really quite a good example, I think, because at the end of the day, the digital euro is something that's being sandboxed and it's being rolled out hopefully soon, and it's actually a cross-border application, within the eurozone, but possibly maybe even outside of it at some point, but at least between countries. Now, if I may. You've mentioned already the lex monetaire, of course, banking law, interbanking law, and one of the issues that, of course, has arisen is contract law. And our project experts, of course, have noted, they've discussed with some detail the implications of CBDCs being the object of a contract. So as opposed to just merely the means to pay a contractual obligation. So for example, in a foreign exchange transaction. In your opinion, what does this imply for CBDCs and international commercial law? And what would the role of party autonomy be in the cross-border use, in this case, of CBDCs?
Yes, I'm not sure, but the first question, I'm not sure that from a private international law issue that the rules would be different if the CBDCs is used just as a means of payment or if it is the object itself of a contract. However, that might have some fiscal implication. maybe. But from a private international law perspective, I'm not so sure. And regarding the role of party autonomy in the cross-border use of CBDCs, well, this is a good question. We have to see what I think that some party autonomy will exist as long as the lex monetae will allow it. But when it comes to monetary law, I think party autonomy, this is it belongs to more the contractual world. And what is difficult with the law applicable to CBDCs is that we have a mix of monetary law, which means public law rules, so with some imperative forms of application. But in the meantime, this is a payment, so the payment of an obligation, and so maybe the law applicable to this obligation, which justifies, which is the underlying obligation, then applies. So we have to coordinate these monetary law rules with the contractual rules. For instance, when you speak about a contractual obligation, so party autonomy probably, but then I see, so, of course, some possible limitations by the lex monetae.
Super, thank you. Now, if we could turn to jurisdiction as the next private international law question, in your opinion, what questions relating to jurisdiction would you consider important to ask when transacting across borders with digital currencies such as CBDCs or other forms of digital currencies, or whether they're issued by central banks or otherwise?
Yes, that's a new topic, I think, because the attention is really on the conflict of laws rule. And I think that the traditional view is to deny any relevance of the monetary transactions for the purpose of establishing jurisdiction. If I take the example of, again, I'm sorry, EU law or even French law, when it comes to determine jurisdiction of a tribunal, for instance, for a contractual matter, the monetary obligation of the contract is not considered as being a possible obligation to establish jurisdiction. Okay, so what you have to look at is the principal obligation, but the monetary obligation is never the main obligation. So this is not regarded as a possible criteria to establish jurisdiction. So this is the traditional view. But I think that this traditional view could maybe change, and that we could also see the use of a certain monetary unit as a possible connecting factor to establish jurisdiction. But of course, we must be very precautious here before really saying these kind of things. But now we see that payment is not just the accessory of an obligation. This is not just the performance of an obligation, because payment in itself entails the conclusion of contract, and sometimes contracts with the plural. So in order to perform an obligation, you need to enter into a new contract. So that means, the relationship concerning the payment, I think nowadays is seen as more important than it was. And I think that something participated in that is that the openness, the building of a market for a payment, for payment institutions nowadays, there's a market for the payments, and we have seen many new companies entering into that market, because now just the fact that somebody can pay someone else is by itself the object of a market. And so this leads to the conclusion of other contracts. And so because the legal importance, I could say, of the payment now could lead to the establishment of a criteria of jurisdiction based just on the payment, and so hence maybe on the use of the monetary union, of the monetary unit, or something like that. So I think that there's this is something really to be thought through. I'm not really sure whether it should be done, but this is something that really needs to be thought.
Thank you. While we have you, we're going to abuse your expertise because you've given us such insightful input to this. Now, are there other matters that you consider underexplored, but particularly ripe for exploration, so that's timely, desirable, that's feasible for us to look at regarding the private international law surrounding CBDCs or maybe cross-border payment systems?
No, I think that we've addressed all, but one important issue, of course, is the law that will apply to the protection of personal data, because well, this is still each state has its own legislation, or may have its own legislation on this issue. And may also another issue to be thought is the fight against money laundering and the financial of terrorism, which legislation will apply to this kind of payments. This kind of issues that should also be thought of.
Thank you so much. Now, perhaps just to circle back, and let me refer then to the beginning of your excellent chapter, which I recommend to everyone who's watching us, who's watching this after this live streaming as well, to get a hold of this book and read this wonderful chapter if you're interested in CBDCs. Now, at the beginning of your chapter, which is titled Laws Applicable to Central Bank Digital Currencies, you began with a very pithy quote, and I'm going to quote it here. More than 20 years ago, international payments were qualified in terms of in conflict of laws as quite intractable. Now, this was attributed, of course, to Professor Luca Radicati di Brozzolo. And you noted that this was written, of course, prior to the introduction of today's private digital currencies, as well as CBDCs. I'm wondering, in light of our discussion today, how does this assessment hold up? And how would you sum up, in a few words, your current attitude to the law on international payments or payment systems?
Yeah, I use this quote because, well, I like very much what Professor Luca Radicati di Brozzolo wrote on this issue, and he was one of the few authors who at that time was interested in the law of international payments. There were others, but not so many, I must say, in the doctrine of private international law. So I think what it was considered very difficult, very complicated at that time, and I think that the complexity has just grown with all the possibilities. I mean, how to pay now? We have many possibilities. So I think that it is very important to have to succeed in having a good conflict of law rules, maybe also rules of jurisdiction, we'll see, concerning international payments. And I would like also, well, to mention that in the 90s, the focus of the doctrine was on electronic transfer of funds. I mean, that was quite new with the beginning of internet, etc., where payments were made differently, quicker, etc. And so the UNCITRAL elaborated a model law in 1992 on international credit transfer. So this was a new topic, and so it was handled by the UNCITRAL by proposing this model law. This model law, which has inspired the EU legislator when it made the regulation on the cross-border payments, and also an inspiration for the directive on the payment services. I have no knowledge that CBDCs is on the agenda of the UNCITRAL, but this is really a topic that is quite new. And as it was new in the 90s, the use of the electronic means to realize payments, and now we really have to deal with this new phenomenon and seeing whether our known solution, the solution that exists today, are still valid for this new form of paying.
Thank you. So maybe just as a blue sky, kind of final thoughts that you might have in this conversation. Now, in your opinion, completely blue sky thinking, what private international laws issues do you think relating to cross-border payment systems? So, even looking beyond CBDCs, cross-border international payment systems, what kind of issues do you think the HCCH should work on as a priority, and why would you think so?
Oh, a very difficult question. Yeah, considering international payment in itself and disregarding just CBDCs, I think that would be helpful to have a clear conflict of law rules of what law applies to the validity of a payment. So there was a European convention at some time about the foreign money obligations, but without really any success. So that's a topic. I think that it seems so complex that we can never achieve a very well-drafted conflict of law rules, or maybe because many interests are at stake. But that could be helpful to have a well-drafted conflict of law rules on international payments. Yeah, and the Hague Conference, of course, is the best place to do that.
Thank you so much. I think we're up for a challenge if our members think that that's the case as well. Thank you so much for joining us. I know you have a very busy schedule. So thank you very much, Professor Kleiner. Caroline, it's a wonderful experience to have you with us. It's a privilege. Thank you so much for sharing your insights with us.
Thank you very much for the invitation. Thank you so much.